owners.
And that's the other thing that concerns me. Some gun owners not going to know because they're not watching this news like this all the time, and they're going to get popped somewhere. And I don't know if it's a misdemeanor or a felony, but you're going to go. We've essentially just taken a large swath of California citizens who are not criminals and potentially made them criminals. I'm so sick of these laws where they make Californians criminals who aren't.
Overnight, at the stroke of a politician's
right.
pen, the gun that you've had for 20 years becomes a quote-unquote assault weapon, and you become a felon. You didn't do anything. The gun didn't come out of that safe. The gun didn't,
The gun didn't do anything. You didn't do anything, right? You were legal a minute ago.
That's the legacy of California's gun laws. Accidental felons. That's what you get from these gun laws, not more safety.
Get out of my house, dude. Don't come through the door. I will shoot.
Chuck, thanks for joining me. The Nutty Ninth strikes again. We had that happen yesterday with the Duncan case. Not unexpected, kind of a bummer. The timing might be interesting, because we have a different president, but nevertheless, can you kind of tell us what happened? Give us some background on this case that we're not getting elsewhere.
Yeah, this is the law that bans it banned the acquisition of magazines that can hold over 10 rounds. I want to say that was like 90. Well, I forget the year, but they banned the acquisition. Then they went back and banned all the possession of the people who had their grandfathered in magazines for years. So it was a complete ban on possession of magazines that can hold over 10 rounds. We filed a lawsuit in 2017. We filed in San Diego. We got Judge Benitez. It was one of the first cases that Judge Benitez got. We won in front of him. It went up to the Ninth Circuit 3-judge panel. We won in front of the 3-judge panel. The state appealed it to the en banc panel, and this is where the shenanigans began years ago. We lost 7-4 in front of the 3-judge panel, en banc panel, 11-judge panel. We took it up to the Supreme Court. Bruin came down while Duncan was pending in the Supreme Court. In light of Bruin, the Supreme Court vacated the en banc panel decision and sent it back down to the en banc court to say, reconsider your ruling in light of what we just said in Bruin. En banc panel, rather than addressing it there, sent it back down to Judge Benitez again. Judge Benitez held a second trial on this. We won again. It then went back up and bypassed a 3-judge panel and went to the en banc panel. And this is where there were some allegations of shenanigans by the en banc panel taking this case back. And so yesterday we got a ruling that by the en banc panel that said it's okay for us to do that. That's sort of a sideshow. The main issue, which was whether or not the Second Amendment protected magazines that can hold over 10, standard capacity magazines that can hold over 10 rounds.
Yeah, we should clarify. People call them, in California, they like to call them high capacity magazines, but they're just regular mags. We have the neutered ones here, but the standard mag is 15 rounds or 17 rounds or 21 rounds or 30 rounds or whatever comes with a gun.
Exactly. They're not high capacity. They're standard capacity. 10 round is low capacity.
Right. And then what's funny about it, one of the arguments, I love the dissents, by the way, from both Bumate, I guess is how he says his name, and Van Dyke. Both of the dissents were interesting and blistering, actually. But I've never seen a judge do a video dissent before. That was interesting. Any comments on that?
That was unprecedented and fantastic. And there is a lot of controversy, a lot of coverage of not just this case, but the fact that Judge Van Dyke did that video. If you haven't seen that video, you should put a link to the video in the comments, because if you haven't seen it, you definitely need to watch it, because he makes them look like idiots. And this is the reality. When you have a judge who knows something about guns, that judge can see through the BS that's being spun by the government lawyers. That's what happened to us in Illinois. We had a district court judge who knew about guns and knew how they worked and knew the difference between the front end and the back end, which most judges don't. And so you're going to win because they know the chances are much greater that you're going to win because they know what the truth is about how guns operate and what the difference is between a magazine that holds 10 or 17 rounds and a semi-automatic or a fully automatic or a single, the different action types. So Judge Van Dyke put together this video that shows how a gun gets assembled because he wanted to demonstrate how wrong the majority opinion, the 7 judges, were in saying that a magazine that holds over 10 rounds is not an arm; it's an accessory. It's an accoutrement that it's an optional part of a gun, so it's not protected by the Second Amendment. Remember, the test under Bruin is, first of all, does the language of the Second Amendment, the right to keep and bear arms, apply to whatever is being regulated? And that's not just a literal arm, it's ammunition, it's the right to acquire an arm, the right to possess an arm, the right to go to the range and practice with an arm. I say the right to hunt with an arm should be covered by this, because this whole notion of self-defense, while that's been the main topic in a lot of these cases, that's not the only lawful purpose for a firearm, and nor is it what the founders considered to be the only purpose of the Second Amendment. Anyway, the Ninth Circuit said that a magazine that can hold over 10 rounds is not an arm. That was their first holding, 7 out of 11 judges. And then secondarily, even if it was, and this is where Rahimi hurts us, because Rahimi set up a looser connection. Remember the test after you've determined that the Second Amendment language applies, the one-step test is there a historical law that's close enough to this law that would indicate that the founding fathers would have tolerated the modern day law? And there's a specific way to figure that out that can't just be any, nebulous, vague law that's designed to make somebody safer. It has to be the historical law has to be passed for the same purpose, and it has to go about accomplishing that purpose in a similar way. Well, the court in the Ninth Circuit just said basically that, we've regulated dangerous products in the past, so we can regulate magazines because magazines that hold over 10 rounds are dangerous. Here's where this breaks down. So, as Judge Van Dyke illustrated, so then what about a grip that makes your gun more accurate? Or what about a red dot sight that makes your gun more accurate? That makes your gun more dangerous if it's in the wrong hands, but it makes it a better self-defense tool if it's in the right hands, because it makes it more accurate and gives you more life-saving opportunities to fend off an attacker if you have more rounds. So, whether a gun is dangerous or not depends on who's holding it. Anyway,
as a firearms instructor with decades of experience doing exactly that, I can tell you the idea that a gun is dangerous is a very good thing. I don't want a gun to defend myself with that isn't dangerous. In fact, I'd like it to be as dangerous as possible. In fact, if I can make it more dangerous than the guy that I'm defending against, that's a really good thing. So the whole idea of dangerousness is absolutely absurd. All guns are dangerous. They're designed, anything that's designed to kill or destroy is dangerous. I want mine to be dangerous. I want the long mags because I want to be more dangerous than the bad guy. And by the way, the bad guy's got the long mags anyway. So now you put bad guys, right? I mean, they're right, and that's the problem. And we've had these home invasion things where you have five, 6 of these guys come bashing through your door. We have these, mass robberies or whatever, where 8, 10 people come in the door and they want to limit you to 10 rounds where you get 1 pill each. Well, the 11th guy doesn't get any. And now I got to say, hold up, guys, hold on. I got to reload. Right.
Yeah, this is where judges think, some of the judges who are clueless about guns, they think, you put one shot in a guy and that drops him. That's, you see that on TV.
Right.
No, you're lucky if it doesn't take a couple, 2, 3 rounds to really stop the threat. Depending on your caliber and that kind of thing.
The truth is handguns are the worst firearms to fight with because they are woefully underpowered. They are the least effective. I haven't looked up the statistics, but I'm going to take a stupid, wild guess and say that probably the majority of people shot with handguns survive. I don't know, I haven't checked. But I would also say the majority of the people shot with a 12 gauge with buckshot or a slug don't. The majority of the people shot with a rifle probably don't. They certainly stop faster because those weapons are far more effective. So
they
if
have
we're
a lot
going to
more
talk
stopping power, yes.
You bet they do. So now we're talking about, there's an old adage, my handgun is just to get me to my rifle. That's what it's for. Or my handgun is to get me to my shotgun, one way or the other to get my long gun. But Americans have chosen handguns overwhelmingly for home defense. The Supreme Court has noticed that. And frankly, you can't get a holster to carry an AR around with you all the time, and they won't let you do it even if you could. So you're going to have a handgun with you, which means if it's woefully inadequate as guns go in comparison to other types of guns, one shot is not going to get it done. And for the judges out there who don't know any better, it's not like Hollywood where you hit the guy in the fingernail and he goes flying through the wall. It doesn't work that way. A lot of times it's multiple rounds have to impact that bad guy to get that bad guy to stop. So if you got 5 bad guys and you got to put 4 pills in each one and you got a 10-round mag, you're screwed.
And that's something that was completely lost on the Ninth Circuit, but not lost on Judge Van Dyke, who did this video dissent. He was one of the 4 judges who dissented. But the real game that they're playing here is, they bend over backwards because they do not want to have a robust, strong Second Amendment protection. Many judges don't. They want to give the government the power, and that just goes forever. I mean, they like, if they can ban magazines as an accoutrement, as an accessory, then can they ban other things like a red dot sight or a custom trigger or custom grips or any manner of modifications, customization that people do to their firearms because of their individualized needs and preferences. And so,
well, for that matter, to Judge Van Dyke's point, if you haven't watched the video, yes, I will put a link in the description. You should watch it because it's absolutely stellar. To his point, the court could go back and say, well, that stock trigger, that's too dangerous.
Right.
Well, you have to have a less effective one in, so you need to install this trigger because that's the one that we approve. Yeah, I mean, judging, if you use their methodology, they could absolutely do that.
Yep. And so, but the concern is that they've really bastardized the test of what is an arm, and then they've watered down the test of what kind of a historical analog law will justify a modern law. And if they get away with that, the methodology, not necessarily about magazines, the methodology gets watered down, then courts who don't want to respect the Second Amendment will be able to use that to to uphold other unconstitutional laws. So we really need the Second Amendment, the Supreme Court, and this is not just from the Duncan case, although the Duncan case was the furthest along, and it is the most well-developed. It's been tried twice, and there's a judgment. It's not a preliminary injunction request like many of these cases are, where they file a motion for a preliminary injunction, and immediately after filing the case, you don't go through trial and discovery and everything to get up to trial. And then that goes up to the Court of Appeals. Well, the Supreme Court doesn't really want to take those. It showed that pretty clearly by turning down several Second Amendment cases where it was an appeal from an injunction grant or denial. They want a judgment. They want a final judgment where the case has gone through all the motions, all the evidence been presented, the witnesses have been presented, and all the evidence has been evaluated by the court a couple of times in the district trial court and then in the Court of Appeal. Then the Supreme Court looks at that. They have the whole record. They're much more inclined to take it, and that's what they've got in Duncan. But the Supreme Court knows that it has got to take a Second Amendment case and set the record straight, set the test straight, and smack down some of these lower courts that are really twisting what Bruin said and Heller said to try and uphold unconstitutional laws.
How do you know that they? And it sounds like a stupid question, I guess. You've got your finger on the pulse of this, and I certainly don't. But one of the frustrating things about this, which is frustrating for you and frustrating for gun owners, of which you are one, is the fact that because the Supreme Court takes so few court cases every year, lower courts can get away with this crap for years. I mean, to your point, this case has been bouncing back and forth since 2017. I'm getting a lot older and a lot grayer, and so are you, as we try to fight through this stupid thing. at what point does the court finally just deal with this? I mean, I read the decision last night. I found it very interesting. I read the dissents. I really enjoyed those. But the Ninth Circuit twisted, they essentially just completely disobeyed the Supreme Court's direction.
Right.
They violated the Constitution knowingly, willingly, intentionally, and they can get away with it because, unlike me, if I violate a Supreme Court ruling in a criminal case, I can get arrested and thrown in prison. But if the Ninth Circuit decides to violate the Supreme Court decision, there is no consequence for them. So they know they can do this repeatedly, and nobody's going to do anything to them because impeaching them is nearly impossible. They are stuck there for life, and we are stuck with their decisions. And now that they've made a decision which is wholly unconstitutional, you, me, and every other Californian and everybody that falls within the Ninth Circuit, depending on what other states want to do, but certainly in California, have to abide by that unconstitutional ruling, even though they got there by violating the Constitution and disobeying the Superior Court. Their Superior Court, the Supreme Court.
Yeah.
At what point does this stop? And at what point does the Supreme Court finally do something? And how do you feel? How do you know that they really want to? I begin to wonder sometimes.
Well, we know that Justice Thomas and Alito do because they've issued dissents when the court declined to take a case, and Justice Thomas dissented in the Rahimi case because they watered down the connection, the historical analog connection. But we know that we have at least 5, maybe even 6 judges who want to do this, but some of them get more wrapped around the axle on procedure and wanting the perfect vehicle and not wanting a politicized, although I don't think they care that much about the politics. You know, we've got 2 cases there now. We've got a magazine case in the Supreme Court now, Ocean State Tactical, and we've got a semi-auto ban case in the Supreme Court now, Snopes. I think they have a conference on the 28th.
They keep kicking the can down the road where Snopes is, don't they? I mean,
yes, and that, depending on how you read the tea leaves, you know, on Dobbs they kicked it, the abortion case they kicked it down multiple times, but often when they're kicking it this far, it's because there's some kind of a dissent being written because they're not going to take the case. But that's not necessarily true. But
could they have been waiting for Duncan to drop?
Yeah, yes, or some other case,
or some other case,
with a complete record, because I can't remember if Snopes is a judgment or not. But in any event, there may be some procedural side distraction that makes the case less popular with the Supreme Court. But they know they've got to do it, and they don't have to hurry now because, well, they should be, they do.
We hope they will, but they won't.
Because Trump is in there. With the Trump administration, they don't have to worry about some of our pro Second Amendment judges retiring and being replaced by, you know, a Kamala Harris appointee.
Well, at least not until the next election in 26. I mean, they got to do it before 26 because if we lose the Senate, all bets are off. So they got to do it before that.
Well, I think you know this presents an opportunity. There's a couple other cases, but I am very optimistic about the Supreme Court taking this case.
Well, that's good, because I was just going to ask you where do we go from here, but it sounds like you just answered that question. Now, I think you mentioned it a little bit earlier, but just in case, if a Californian has mags now, I'm just, you know, John Smith has a whole bunch of normal capacity mags, what California would call high capacity mags, because John either had them before the original ban or John bought them during the week that Judge Benitez gave us that we affectionately call Freedom Week. What happens to those mags now? Are we still in a position where Californians still get to keep them?
No, there's no grandfathering on this. This is what's so sinister and duplicitous about how the legislature acts. They passed a law that says we're going to ban the future acquisition of magazines. And we say that's unconstitutional, that's not going to work, that's not going to bring crime down, and it never has. And so then they say, yeah, you know, we got to go further. And this is what they always do. We're going to pass this law, and it's going to make us all safer. It doesn't make anybody safer. Oh, that's because it didn't go far enough. So first they ban the acquisition of magazines that hold over 10, and then a couple of years later, they ban the possession outright. So all those gun magazines that were grandfathered in are now illegal too. So that's where we're at. That's what the law is now. You cannot possess a magazine that holds over 10 rounds in the state of California. Now that's not in effect yet. So nobody has to go out and have a boating accident just yet. But
you say that, but and that's a joke, but I'm going to tell you right now. You can now take the definition of mass non-compliance out of the dictionary and insert the mag ban in the definition, because there will be mass non-compliance. People are not going to take their hard-earned money they spent on mags, which are constitutionally legal, and throw them in the ash can, turn them into California, take them to their cousin's house in Nevada or whatever. They're just going to put them in a drawer or a box in their garage and leave them there until this thing goes through. I mean, that's my prediction, right? I'm a public figure, sort of. So if this goes through, then I'll take mine to my Arizona house and drop them off there, because I can't afford to take chances like that. But the average person, there's no reason for them to do that. That's just not legal advice if you're watching this. I'm just saying.
Yeah, I can't sanction this as an attorney.
No, I know you can't.
I'm
not either. I'm just. I'm not sanctioning it. I know you're not, but I'm just being real about it. The reality is there's going to be a mass non-compliance about this.
And what concerns me is now a lot of people aren't even going to know. It's not like every gun owner.
And that's the other thing that concerns me. Some gun owners not going to know because they're not watching this news like this all the time, and they're going to get popped somewhere. And I don't know if it's a misdemeanor or a felony, but you're going to go. We've essentially just taken a large swath of California citizens who are not criminals and potentially made them criminals. I'm so sick of these laws where they make Californians criminals who aren't.
Overnight, at the stroke of a politician's pen, the gun that you've had for 20 years becomes a quote-unquote assault weapon, and you become a felon. You didn't do anything. The gun didn't come out of that safe. The gun didn't,
The gun didn't do anything. You didn't do anything, right? You were legal a minute ago.
That's the legacy of California's gun laws. Accidental felons. That's what you get from these gun laws, not more safety.
It's crazy. It's absolutely crazy. All right, well, I guess... there were some other cases, I think, stacked behind Duncan, weren't there? I don't know what they were, but I don't know why, because I don't know that this didn't change anything. What's stacked behind Duncan?
Well, you've got Boland, the ammo background check and interstate ammo purchase ban. We've got Rhodey, the ammunition. Well, Boland is the roster. Excuse me. Roland is the roster. Rhodey is the ammunition purchase ban. And we've got May, which is the sensitive places case. We've got another, 6 or 7 or 8 more cases which are in play and weren't really stopped by Duncan, but there's several that were stayed pending the Duncan decision. Now we'll see, they'll probably all come back to life. So there's going to be a lot of work that we have to do to deal with those cases and to get Duncan to the Supreme Court. So obviously, if folks can support CRPA, to help us get some of that work.
Oh, absolutely, done. Yeah.
And while I'm at it, let me give a hat tip to NRA for helping to support the Duncan case, and we'll work with them as we move it towards the Supreme Court. They've been involved, but that's that. The CRPA is still doing a lot of the labor on this.
I'm just stunned by the fact that NRA did something. It's been a while.
Well, it started a long time ago.
Well, okay. But I mean, there for a while. I'm a life member of NRA and have been forever, but I mean, they've been kind of, on another planet for the longest time, but I'm glad that they're helping. That's great. I guess last question. We talked about, I'm going to ask you to prognosticate now, and I know you can't, but I do. I ask you this every time. What do you think the odds are that the Supreme Court actually takes this case? Are they good? Are they poor? I mean,
I'd say it's 80%.
Really? Favorable?
Yeah. This case has been on the radar for a while, including the Supreme Court's radar. Remember, they took it once, and they vacated it. And they vacated the previous en banc opinion. So they're very much aware of this case, and I think they're very much aware of that it's fully developed, and so it's a good vehicle to decide, and it's not semi-autos. They may be, although I don't think they're politically shy about semi-autos. But if there is any political hesitation, there's no need to have that hesitation with a pure magazine case. So I think we got about an 80% chance of it being taken. Remember, only 1 out of 100 cases are ever taken by the Supreme Court. But Second Amendment is a hot topic. It's a evolving area of legal jurisprudence. And by the way, we are at a historic time in Second Amendment law, in the development of Second Amendment law. This is stuff that's going to set the stage for how gun laws are passed or struck down for 50, 100 years. This is where our children are going to live, and us in the short term. But our children and our grandchildren, this is the world that they're going to live in when it comes to the right to keep and bear arms. So this is historic time, and if you make a support the CRPA, you're part of that history on this case, and other supporting other.
That brings up Chuck. I'm sorry to interrupt you, but that brings up an interesting question, because I've wondered about this, and I think you and I have talked about this probably a number of times, but I suspect I'm not the only person that wonders about it. Why are we having to go through this with the Second Amendment? We don't have to go through it with the First Amendment. We don't have to go through it with the Fourth Amendment. We don't have to. We
actually did this. The First Amendment, there was a growing stage. There was definitely like an era when the First Amendment jurisprudence was fleshed out. So, and that's not unusual for when there's some big pronouncement that a constitutional right means something. They figure out exactly what it means. So we're going to have even now the CRPA is very involved in the CCW reckoning project in California, where these jurisdictions, they now begrudgingly acknowledge that they have to issue licenses to carry, but they want to make it cost too much. They want to make it take too long. They want to be able to deny people for no real constitutional reason. And you wait two years to get a permit that's only good for 2 years, which is why CRPA has a bill in Sacramento right now to extend the period to 4 years for a permit and 4 years on a renewal rather than 2, because it's ridiculous to have to do this every 2 years.
By the way, since you mentioned that, hold on, drum roll, please. I don't have a drum, but here we go. Ready? That's the best I can do. I believe it's as of April 22nd, that would be next month, out-of-state residents can start applying for concealed carry permits.
That's right.
And at this moment, it's a bit of a Charlie Foxtrot at the San Diego Sheriff's Office, not because they're trying to make it hard, but because they're just trying to figure out how to do it. Yep. We had a big meeting with all the instructors the other day, and so it's kind of a mess, but they're working feverishly trying to get that sorted out. But yes, that is a case in court. There's an example of the courts actually helping us where we can do this. Go ahead.
That's another CRPA case, hat tip to Gun Owners of America and SAF for Second Amendment Foundation for being involved with us on that one. But that's because, we forced the LA County Sheriff and the state to start accepting that, because your constitutional right to bear an arm in public does not end at the state line. So you've got to allow out-of-state residents to apply.
Yeah, it's going to be a zoo for a while. So if you're an out-of-state resident,
and that's the reality. Look, some of these issuing jurisdictions are taking too long. It's because they have more applications now than they've ever had before. I acknowledge some of it is a legitimate reason, but you know what? We didn't create the licensing scheme.
My rights
do not.
Government
created the licensing scheme, and if they're trying to make it harder for somebody to get a permit, then that's on you to pay to put somebody through the process, and that's you to put more resources, government, in place so you can process the applications faster or streamline the system so that it doesn't take so long and cost so much. Otherwise, you pay it, and you pay for people to process the applications in time.
During the meeting with the sheriff, and I want to commend them. They're trying very hard to get it done, so I'm not picking on them. But it came up, why didn't they, this is, and we had to do this, and then we had Bruin, and then we had this. And I said, you know what? At Bruin, the state could have just decided to become a constitutional carry state. It's not gun owners who made this decision that you have to have this wonky ass process that we have to go through in order to get a permit. You could be like Arizona. You could be like Utah. You could be like 40 some odd states, like the majority of the states. We could be that way in California, where you could just put a gun in your pocket and go where you want. But no, California decided they wanted to do this. And so if you have to suffer through the difficulty, it's on you.
Yeah,
it's
even
not on
in
me.
the states that have the license that issue licenses, or maybe give you the option, constitutional carry or get a license. And I would get a license, by the way, even in those constitutional carry states, because that's kind of like if you ever get pulled over and you show a concealed carry license, the officer knows you've had a background check and he's not going to be as nervous around you. But the point is, even in the states where you want to get a license, or it doesn't cost very much and it doesn't take very long.
Oh, as you know, I have a home in Arizona. I think you got one in Nevada or someplace, don't you? And then, look, I have a permit in Arizona. I think it took 45 days to get it. Cost me $50, right?
Exactly.
I mean, Utah, I believe, has a law that says they have to issue the permit to you within 60 days of receiving a complete application and your fee. And Utah's got how many millions of permits out? I mean, if they can do it in 60 days, and right now I think they're running at 45. If they can do it in 45 days, why does it take California a year and a half?
Bingo.
Right? So there's no excuse. I mean, they can whine and they can complain, and I get it. And if you're an employee there, you didn't make the decision, you're stuck with it, but nevertheless. And the other thing I want to mention, too, about, and as a member of CRPA and Gun Owners of America and Gun Owners of California, CRPA and Gun Owners of California are the only organizations that have full-time lobbyists up in Sacramento. Nope, I don't care what anybody else tells you.
Dedicated just to California, yes.
Yeah, in California. I mean, in Sacramento, they're the only ones that do. So if you're in California and you want to have somebody up there representing you, those are the two organizations to join. I don't care what any other organization tells you. If they tell you they're up there all the time, it's baloney. They're not. CRPA is. Gun Owners of California are. You should join those two organizations. This joker right here and his lawyers are involved in these things up to here, fighting in court for you. So you need to help them. Don't you have a Second Amendment Law Center as well?
Yeah, the Second Amendment Law Center was created by me and the leading Second Amendment lawyers and scholars in the country to coordinate friend of the court brief campaigns, because a lot of times the parties to a lawsuit can't, you have page limitations, you have to focus on a certain topics that you deem to be the most important, but there are other things that the court needs to know that can only get in front of the court through a friend of the court brief, an amicus brief. So Second Amendment Law Center runs amicus campaigns all across the country, not just in California, to try and make sure that the judges are fully informed and maximize the chances of winning. And that's another organization, that's another nonprofit that you could help support by going to 2alc.org, and the CRPA is crpa.org. But yeah, again, it's a historic time. Throw in a couple of bucks and you'll be a part of it.
I'll put links in the description. You just brought up something, and I'm sorry. I said one last question. I have one last question. I apologize. So we got the Trump administration and big changes, it looks like, at DOJ. Does the Federal Department of Justice write amicus briefs on these things when they get to the Supreme Court, one way or the other? And if they do, does that help us when we have a different administration?
Heck yes.
You can say hell yes. It's okay.
Hell yeah. Hell yeah. And we are already reaching out to various folks inside the administration, asking them to take a look. This was part of the submission that went into Pam Bondi at Trump's instruction, letting them know about what positions the U.S. government has been taking in the past, asking them to reevaluate those positions, telling them about some of the shenanigans being played by courts and by state and local officials. So I think we're going to see a lot of movement from the Department of Justice and the ATF in our favor. And we're trying to help push that along.
I just saw a post on X, I think. I believe it was Kash Patel, who said he was visiting with ATF and going over what the administration wanted and didn't want, and what ATF will be doing and won't be doing, and that we can expect very positive changes because and he even quoted the Second Amendment, and he quoted the right of the people to keep and bear arms shall not be infringed, and that came from, I think it was Kash Patel. I could be wrong, but I thought that was pretty amazing. I actually had to pinch myself and see if I was actually awake or was I dreaming. I mean, it's
a sea change, and this is what the election has done for us.
Yeah, huge stuff. Well, Chuck, thank you very much. Have a great week, brother, and have a good weekend. And thank you very much for coming on.
My pleasure, brother. Thanks for helping get the word out.
Anytime.